Hello friends, this is Mange Karan Ratanbhai and today I am going to talk about Personal Data Protection Bill of 2019. After the judgment passed in K. PUTTUSWAMY versus Union of India, right to privacy was declared as a fundamental right by the Supreme Court of India. After that, a committee was formed which was led by Justice B. N. Shri Krishna for the statutory framework of the bill. The Personal Data Protection Bill is introduced in the Parliament in the year 2019. Right now it is the proposed law and it is going to be presented in the parliamentary session of year 2022. The object of the bill is to protect the personal data and regulate the flow of the data. Under the Personal Data Protection Bill, a DPA authority, which is also known as Data Protection Authority, is formed, the constitution of which is maximum 7 members including the chairperson and 1 member with experience and qualification in the law. All the 7 members' terms shall be for 5 years or until they attain the age of 65, whichever is earlier. A selection committee for the same, which shall consist of 3 officers headed by the Cabinet Secretary along with Law Secretary and Secretary of Ministry of Department of Electronics and IT. Any particular method or procedure is not provided for the selection, but all the 3 must be bureaucrats and may or may not possess the subject matter expertise. So what are the objects of this DPA? So the statutory object of the DPA is to protect the individual interest, prevent the misuse of personal data, and ensure compliance and promote awareness about the data protection. The functions of DPA is to promote concepts like consent, purpose, and storage limitation, data minimization, prescribe the obligations on data fiduciaries, which are also known as data collectors, who must collect data for precise purpose with express consent of the individuals who are the data principals. Other function is to confer rights on data principal, including restriction or prevent the disclosure of data. The DPA can also empower the central government to exempt any of the government agencies from the purview of this law. So what are the powers of DPA? The powers of chairperson is described under section 45 of the bill. General superintendence and direction. Any power to do anything which can be done by DPA as a whole. The powers of DPA are extensive powers to enforce its obligations, regulate significant data fiduciaries, monitor cross-border transfer of data, specify codes of practice, develop mechanisms for creating data trust scores, and other functions as may be prescribed. DPA or an inquiry officer has power analogous to a civil court under CPC for 5 types of matter, including discovery and production of documents, summoning and enforcing presence of persons and examining them on oath, inspection of documents, records of data fiduciary, issuing commissions to examine witness or documents, and any other matter which may be prescribed. Also, a proposed authority shall be vested with powers to seek info and conduct search and seizure of locations where it is believed that some data or document can be either compromised or destroyed. Making regulations, rules, safeguards for the protection of privacy and restriction on continuous or systematic collection of sensitive personal data, etc. Some of the powers of central government as per the draft are ability to issue periodic directions, right to interpret any policies for the benefit of India's digital economy. Government in consultation with DPA can direct data collectors to hand over anonymized personal info or other non-personal data for the purpose of evidence-based policy making. Government can exempt any of its government agency from the purview of this law. To conclude, this draft remains silent on the procedure of how the fundamental right of privacy will be protected. There is a minimum level of protection for the personal data and high degree of potential intervention by the government. Control of government in every aspect of DPA, along with its authority combined, has given discretionary powers and insufficient accountabilities, which are a matter of concern. Exceptions made for government authorities in collection rules, reporting, and other requirements is again a question of how the right to privacy is protected. Thanks a lot everyone for listening. If you like the video, please share it, and for suggestions you can comment down in the comment section. Thanks a lot.